I don't really remember all of what happened the night I was arrested because I was intoxicated and stuff.
I started drinking, doing drugs, so I kept getting in trouble with the law. So I kept going back and forth in jail and in jail.
I was just like, what have I done? You know, what have I become?
You know, it takes a village to raise a child. And I think that's the perspective that the Youth Criminal Justice Act is coming from.
It's about real consequences happening right away, and youth can relate to that.
I think it's important to remember that it's kind of not a one-size-fits-all approach, that we have to pay attention to every youth that we come into contact with.
They get to take responsibility for what they've done and really own up to it. And for a lot of people, that's really freeing.
The Youth Criminal Justice Act, or YCJA, is the federal law which governs Canada's youth justice system. The Act applies to Canadian youth aged 12 to 17 who get into trouble with the law. The YCJA came into force in 2003 and was amended in 2012 to strengthen its handling of violent and repeat young offenders.
Almost every country in the world has some special legislation or provisions that recognize that children and adolescents are not to be treated in the same way as adults, that they have a limited state of maturity, they have a limited state of moral development, intellectual development, and they are often more amenable to rehabilitation.
The Youth Criminal Justice Act states that the youth criminal justice system is intended to protect the public by holding youth accountable, promoting the rehabilitation and reintegration of youth back into society, and preventing crime. It emphasizes that the youth criminal justice system must be separate from the adult system, and based on the principle that youth are presumed to be less morally blameworthy than adults. In other words, the law recognizes that youth must be held accountable, but in a way that takes into account their greater dependency and reduced level of maturity.
A key objective, a key principle of the Act is to promote the protection of the Canadian public. And that includes the short-term protection, which may in some circumstances mean removing a young offender from the community. But it also includes the long-term protection of society by rehabilitating young people, by dealing with their underlying problems. It also provides more structure to the decision-making of judges, probation officers, and others, and tries to ensure that custody is used as a last resort, and it's largely been successful in achieving that.
This is a much improved situation than we had before under the Young Offenders Act, because I am now looking more at not just representing clients, but we have to look at trying to find ways to deal with underlying issues which the court might need to address in sentencing in order to assist in the rehabilitation of young persons.
The majority of youth crimes involve non-violent activities, such as shoplifting, possession of stolen property, breach of probation, or relatively minor assaults that do not involve bodily harm. Experience in Canada and other countries shows that measures outside the formal court process can provide an effective response to youth crime, and one of the key objectives of the Youth Criminal Justice Act is to encourage the use of non-court responses in appropriate cases. These extrajudicial measures can provide meaningful consequences, such as requiring the young person to repair the harm done to the victim. They also allow early intervention with young people and provide the opportunity for the broader community to play an important role in developing community-based responses to youth crime.
The Act does give police officers the discretion to use pre-charge options, and in fact it requires them to give first consideration to the use of extrajudicial measures as a means of addressing offending behavior. The police officer can choose to verbally warn the youth or issue a formal caution where the youth is actually formally warned that they could be charged if that type of offending behavior continues. The police officer can convene a conference to call together our community partners for the purpose of making recommendations related to appropriate extrajudicial measures.